My name is Nika Gavrilović, and I'm a recent graduate at Faculty of Law, University of Zagreb. Firstly, I would like to thank all the lecturers, because as I'm one of the youngest participants, it has been a real pleasure to hear all your presentations and lectures. So the topic that I will discuss today concerns the EU legal framework for motor vehicles and the novelty that EU regulation on the approval and market surveillance of motor vehicle will introduce. As Professor Mutic already mentioned, this is quite technical, and it's mostly related to regulatory procedures and compliance aspects of the motor vehicle. But I will try to explain briefly how the motor vehicles are introduced and placed on the EU market, and I will speak about the obligations of the manufacturers as well as the other economic operators, and I will talk a bit about post-market surveillance systems, and I will also touch upon a subject of the general safety regulation that is concerning motor vehicles, as well as it was revised last November, and it is introducing a lot of new interesting devices. And then in the end, I will raise a few questions that I think are critical for the future developments in this industry. So motor vehicle regulation became fully applicable 9 days ago, so on the 1st September, and therefore it has repealed the motor vehicle directive. Although it is a regulation, it is considered to be one of the new approach directives. New approach directives are the EU directives or regulations at this point that define the so-called essential requirements, which are technical and administrative requirements related to health, safety, and environmental issues that all the products that are to be placed on the EU single market must meet. So all these regulations and directives are basically a combination of the standardization and legislation at the EU level, and this was introduced on the EU level in 1985. So it's been here for a while, and now recent developments are in a way that all these directives are, so to speak, becoming regulations, which also shows that the EU is trying to govern and regulate the EU single market more at their own level, and it's leaving less and less space to maneuver to the member states. This particular regulation is reforming the type approval and market surveillance systems for the motor vehicles that are of this system that was applicable while the motor vehicle directive was still on. The reason for this was to detect all the non-compliance cases at an earlier stage, and for all the market surveillance bodies to be able to have a higher level of control, and to have European Commission performing an oversight of the type approval process. So the scope of this regulation is defined by the regulation itself, of course. It includes the motor vehicles that fall within the category M and category N, and their trailers that fall within the category O. But it is important to mention that this is only for the vehicles that are intended to be used on the public roads. Also, this is not just for vehicles per se, it is also for vehicles that are designed and constructed in more stages, systems, components, separate technical units, or any other parts and equipment that are designed for these vehicles and trailers that fall within those three categories. And it is important to mention that there is a EU type approval procedure and a national type approval system. So in order for a product to be placed on the EU market, all the vehicles must have the EU type approval certificate. In order for the vehicle to get this certificate, it must be assessed. So a certain vehicle must comply with all the regulatory acts that are listed in the Annex 2 of the regulation. This way it's going to get this approval. It is important to mention that this approval is necessary because you need to have this approval for it to even be on the market. In some other industries like medical devices or cosmetics, it is not necessary to have the approval. You can only start placing the products on the market, and this is going to be sufficient. You can self-certify, unlike here where you have to attain this approval or certificate. In short, there are a few steps that all the manufacturers must perform. First, they have to compile all the necessary documentation. Once the documentation is compiled, the documentation needs to be submitted to the EU authority. It is important to mention, because the regulation is emphasizing this in many places, that the manufacturer can submit this application to only one member state and to only one approval authority. And furthermore, even in the submission documentation, the manufacturer has to have a declaration where he states that he has not submitted another application to another EU authority, or that the same one was not revoked, or the product has not been withdrawn before. Once the paperwork is submitted, the notified body or the competent authority is going to assess the compliance of this device, of this vehicle in question, and if the vehicle is found to be compliant, the competent authority is going to issue the EU type approval certificate, and only after that the manufacturer may place the vehicle on the EU market. So as mentioned, the manufacturer is the one that is performing the application and the one that is submitting this application to the European competent authorities for each type of the vehicle. And then he is also including in his application this declaration that I mentioned, where he is certifying that he has not submitted this same application to another EU competent authority, that is, that this same application was not revoked or withdrawn. In it, he must include many documents, like information document that is actually a compilation of all the information of this particular type of the vehicle. Also, all the data, drawings, photographs of the vehicle. He must indicate the procedure that he has chosen and any additional information that the authorities may request. Once the documentation has been submitted, the notified body has to perform the conformity assessment. All the measures there are that the notified body must take into account are addressed in the Annex 4 of the regulation. And then at the end of the assessment, they can decide to either grant the type approval, and therefore they have to issue the type approval certificate, or for the existing one they can amend it or refuse or withdraw it. So this is how the EU type certificate looks like. For many other industries that also are regulated by another new approach directive or regulation, this is also most very important requirement. For example, for all the upper class medical devices that are regulated by medical device directive, in order for the manufacturer to get the CE certificate, that is to be able to place the CE marking on their devices, they have to have the CE certificate. So this is the equivalent here, EU type approval certificate. And these certificates have the validity date, so at some point they will have to be renewed. Here are some, also I mentioned some of the details that have to be on this certificate, but the most important one is filled out specimen of this certificate of conformity that I will talk now about more now. You can see also a picture of it here. It is also called Declaration of Conformity, and it is also present in a lot of others new approach directives or regulations nowadays. The point of this declaration of the conformity is for the manufacturer to declare that he, as the one that is responsible for the devices that he is manufacturing, that these devices are in compliance with all the technical requirements that are laid down in this regulation or in any other new approach declaration, any other new approach legislation. And for vehicles also that is in compliance with the regulatory acts that are listed in the Annex 2. So he's going to have to see what other regulatory acts for his vehicle type he will have to be in compliance with. So obviously he is the one that is responsible for the approval procedure, and he must ensure the compliance of his entire production. There is also a special set of obligations that the manufacturer is having in case that devices that the vehicles that he is producing are not in conformity and that they present a serious risk. But I will touch upon that afterwards when I speak about post-marketing surveillance. Regarding the economic operators, three most important economic operators concerning this industry are European representatives, importers and distributors. European representatives are also present in other new approach directives. They are European bodies, natural or legal persons that are representing the non-EU established manufacturers, and they are actually contact and vigilance point for the European bodies, authorities, or any other even legal and natural persons. So they are all going to contact the EU representative when there is a certain situation with the vehicle or other product that European representative is representing. So they also have to have access to the EU type approval certificate and the declaration or certificate of conformity, and even after the expiry date they have to have it for 5 years, and they must provide all the information and documentation to all the authorities to demonstrate the compliance of the product that they are representing. And they have to cooperate with the approval authorities or any other market surveillance authorities and take actions if they notice that the device they are representing is not compliant. And also they have to inform the manufacturer for any of these situations. Regarding importer and distributors, they have some different and some same obligations and duties, but here are the most important ones that they both share. So they also need to have access and they have to have stored the EU type approval certificate. But the most important thing considering these two operators is that they have to verify that the vehicle is covered by the valid certificate and that all the technical requirements from the regulation and potentially other regulatory acts from the Annex 2 that I keep mentioning are being met. Also, they need to keep record of all the complaints and recalls and communicate them with the other distributors, manufacturer, and if necessary, even the authorities. There is also a special set of obligations for them in case that the vehicles they are placing and making available is not in conformity, but I will also speak about that when I come to the PMS part of this presentation. But now I would like to mention two cases when they will have the same obligations as the manufacturer. This will happen when they are making available on the market one product under their own name or trademark, or when they are modifying a vehicle in a way that the vehicle is not in compliance with the applicable requirements anymore. And other situation is concerning only the manufacturers that are not established in the EU and their EU representative is not possible to be identified. And so if importer and distributors are making available some vehicle on the market on a basis of the UN type approval, they will be responsible for it in case that the manufacturer's EU representative is not being identified. Regarding the post-market surveillance, so the European Commission and all member states have to use the Common Electronic Exchange Systems, RAPEX. This is not just for motor vehicles, this is for all the other products that are being placed on the EU market, where EEC is placing weekly notifications on the products that are not compliant with the EU law in one way or another, and the ICSMS, the Information Communication System on Market Surveillance, where all the type approval certificates, test reports, and amendments will have to be communicated through. And now, what is going to happen if the vehicle is not compliant or it presents a serious risk? So the manufacturer will have to examine it through the so-called CAPA procedure. He will have to take corrective actions or preventive actions, and all this will have to be communicated through to the approval authority. Furthermore, if any of the economic operators notices that the vehicle is not in compliance, they will also have to communicate this to the manufacturer and between each other and cooperate with any of the approval authorities about it. The other regulation that is concerning motor vehicles, and it's also quite new, is General Safety Regulation. This regulation has been revised in November. It has already entered into force this January. It is very interesting regulation because it requires all the vehicle models that are to be introduced to the EU market from July 2020 to have so-called advanced safety features. These advanced safety features are very interesting. For example, they are some softwares that can recognize distraction, or that can actually even prevent the distraction, that can record us different events and accidents, that can keep the car in a certain lane. So these are all very advanced technology that must be equipped, that all the vehicles will have to be equipped with. So the objective of the regulation is to ensure the safety of the vehicles, of course, to have an environmental impact. And one of the objectives was also to improve the European industry competitiveness on the global market. So taking into account these two regulations, there are a few questions that I find particularly interesting. So if we do place all these softwares in the vehicles, how are we going to firstly assess the compliance? At this point, these softwares are being updated by so-called over-the-air update, and in this over-the-air update, we have a delivery of new software or data through wireless technologies. In other new approach directives, for example, for all the radio equipment that falls within radio equipment directive, recently European Commission has issued clarifications on the initiative of upload of software into radio equipment. We don't have such clarification or another document at this point for motor vehicles. Also for medical devices, there is a lot of talk about softwares that are being inserted into medical devices. The question here is, how are we going to assess the compliance once the software is being uploaded? Because the compliance is demonstrated at the moment when we place the vehicle on the market. At the moment, the UNECE has a draft of the new UN regulation on uniform provisions concerning the approval of software update processes. But it is only a draft, so the time will tell. Also, there is a lot of different regulatory setups. In the EU, we have the type approval that I have just explained, while in the USA and Canada, the original equipment manufacturers are the ones that are certifying that the vehicle that they have manufactured is complying with all the rules. For example, in the USA, they are certifying that the vehicle they have manufactured is in compliance with federal motor vehicle safety standards. And these safety standards are mostly just talking about the minimum performance level that the vehicle they are manufacturing has to meet. So it is at this point much easier to place maybe an advanced, so to speak, vehicle on the USA or even Canadian market than on the EU market. And the whole purpose of revising the general safety regulation was to make EU's market more attractive to many manufacturers and to EU manufacturers. For example, in 2019, Sweden threatened to ban Tesla sales because the over-the-air update and autopilot was not very clear. So the time will tell. Another issue that I found interesting was cybersecurity, because is this software update going to make our vehicles prone to hacking? There were many situations where the researchers would prove that these softwares are hackable, and therefore are we going to be in danger? And how can we regulate this legally? Who is going to be responsible for these situations? And the last issue that I will mention briefly, because it's only GDPR, the regulation that everybody is talking about always, how all these softwares that we will have in our cars are going to have a lot of private data on the drivers. So how are we going to properly store and collect this data, and how is this data going to be compliant with GDPR? And with this, I would like to close my presentation. I hope that it was interesting, even though it's pretty technical.